That's okay. All right. Good evening, everybody. First thing that I usually do is look at questions that people have raised. Somebody says, I'm having a little difficulty distinguishing between conditions to closing and just conditions. Okay, so we're going to go over that again because that's very important. They're not the same. We talked about that in the beginning, and it is an issue of struggle. So that's why I pointed out, so that if you're still having trouble with it, that you would say something so that we can all, cover it together. But they're not, remember, how can somebody help me? Now, your conditions, remember those three things, those three buckets of things that we talked about in the beginning. Your conditions are what? Anybody gonna help me? Yes. No, I'm just looking for, you remember those three things we talked about? We talked about our, it's just going to be 2 words. No? No. It's like, remember those 3 things we talked about when we were thinking about how to write a contract? We talked about 3 buckets of things that you have to be focused on. They're numbers. Each one of them has numbers beside it. Remember we talked about?
The action sections?
Okay, so there's the 3 things that I talked to you about those 3 categories of things. So let me refresh your memory. That we talked about in the very beginning, that there are 2 things, how to write a contract and how to think about writing a contract. And so from the beginning, I've been talking to you about these 3 things that you have to be focused on in how to think about writing a contract.
Client's goals.
And so one of them are, so that's you're in the ballpark there. Yes. Okay, we got 7 contract concepts. What else do we have?
5 issues.
We got 5 issues of client concern. And where do we get those issues of client concerns from?
Client's goals.
From the goals. Okay, then what else do we have? Then we have 10 contract sections. Okay, now this thing that I'm talking about, conditions, which one of those 3 things does that fall into? Conditions. Yeah, of those 3 that you just gave me. Concepts. Yes. Thank you. Concepts. Now, a condition to closing, what is that then? Don't be shy, y'all. Just go ahead. I'm listening. Say that again. Sit you so meek and mild. Pardon me. How's the judge going to hear you? Say it loud and proud. Contract section. See, right there. That's the difference right there. A condition to closing, that's going to be one of the sections of the contract. Contract concepts, we use concepts to help us to solve
The client's business issues.
Problems. Yes. Are we getting it now? Go ahead.
Well, couldn't I say that because the closing...
Conditions to closing. Okay.
Conditions to closing.
Conditions to closing.
The delivery of the purchase price is a part of closing.
Okay. But that has nothing to do with conditions to closing. And we're going to get there. Okay. But that, first of all, they're just not the same thing. They're just, 2 different categories of things. Okay, so we're going to talk more as we get into, like today, we're going to talk about action and business section, the action/business section of the contract. Later on, we're going to talk about the conditions to closing section, what you need to put into the condition to closing section of the contract. But you can have conditions in any of these sections.
Including the conditions to close the section?
Possibly, yes.
Have we talked about conditions to close?
No, we haven't. That's why. Yeah, see? You got it. See? We haven't gotten there yet.
I'm thinking I missed something.
No. Well, no, other than there is something called that. Yes, that you know that much at this point. Okay. All right, but we're going to get there. Somebody said, can we go over the difference between conditions and a covenant? Yes, we're going to do that. So this is what I use to kind of guide me on where we're having problems and what we need to cover throughout as we go forward. But we're gonna hopefully answer all questions. If there are questions that are unanswered, then you got to put that on your exit ticket if you're not gonna raise your hand, because some people are very shy. That's okay. All right, so here we go. As we go on, I'm gonna be using my little transaction figures. Some of them you've seen them before, you know. Some of them we talked about before. We're not gonna talk about Ralph so much today. Okay, we're gonna talk a little bit more about Lenny, and we're gonna talk a little bit more about our super cool. It's super cool. It's a super cool. It's cool stove. We're gonna talk about that a little bit more. All right, so let's first talk a little bit, and I gotta move through this. If you have any questions, just please put it on your activity. We're gonna go back and we're gonna look at this factual scenario one more time. And while we're doing that, I'm going to give you, I'm going to introduce you to a deal memo. Let's go back through this again. And I'm wanting you to do this because what we have to do is we have to learn how to spot issues in the sea of a whole lot of just nonsense. Okay, and I'm sure you could see in your transaction materials for transaction number 1, which I know you all loved, that, there's a lot of craziness going on in there. So you're gonna see that it's like distracting information sometimes, just so that you can develop the skill of spotting relevant information. Okay.
The arrangement between me and the defendant was basically a verbal agreement with a bill of sale, actually not a bill of sale, a receipt, stating that we were going to purchase 17 guitars that were used and in decent condition from this shop, Lenny's Music. And they were going to be for the amount of $7,500. And the reason I'm here, the reason I feel I've been disgruntled is the items that we purchased were not up to snuff. They were not what Lenny promised them to be. 9 of them were not working. 9 of them were distorting when they were turned up to volume 5 or more. And therefore, I believe I'm due a refund. What I would like to get across to the judge is this gentleman is basically a shady character and should not be in business, because when you promise something, you should come through. I mean, I'm in business. I know what it's like to make promises, and I feel like I'm an ethical person where if I say I'm going to come through with something, you bet your bottom dollar that you're going to get what I promised. And I'm sorry, but Lenny's Music did not come through.
Oh, this guy come into my shop and asked me for 17 used decent guitars that he was going to use for some outdoor festival. And he needed them by a certain date, and we agreed on $7,500 as the sale price, and I fulfilled my end of the obligation. Well, my position is very clear. In fact, I got it in writing. Truth is that I got a sign up in my shop very clear. It says, no refunds on used merchandise. That's it. I fulfilled my obligation. I got him the guitars. I got him on time. I got him within the price range that we talked about. And he tried them out in my shop. Bing, bang, boom, it's done.
Ms. Sears, why don't you go ahead and tell me a little bit about why you're here today?
Thank you, Your Honor. I am part of a company, it's a record label called Headspin Records. We have 17 clients under our roof, and they're artists that are up and coming. And one of the ways that we get their music out there is by having concerts, outdoor concerts. And this year, what we've done is we've had 17 of our artists come out and perform with used guitars. So the lead guitarist of that band would be playing that used guitar, and then after the concert is over, the entire band would autograph that guitar and it would be given away to one of the members of the audience. Unfortunately, out of the 17 guitars that we purchased from this gentleman, 9 of them were not functioning. When we went to find them and purchase them, he claimed that they were in decent shape.
Now, did you purchase them personally?
Well, I have a production coordinator who did that for me, and his name is Phil Spencer, and he went out there and spoke to Lenny, and he said that he needed these guitars. Lenny said he could get them for him, and so after about 2 months, we finally got a phone call, which was actually 3 days before the event, and said that he finally got all the guitars, and my production coordinator went over there and tested them out, and then they were hurried to our office before the concerts.
Okay.
So I did not actually physically speak to them. This is the first time I'm meeting this gentleman.
Okay, so you spoke to your employee?
Yes, my employee
who
was our middleman.
Okay, okay. And, okay, why don't you, let me know what happened that day when, what was his name again? Phil Spencer visited your shop.
Well, the sacrament, he asked me for a number of guitars, I think it was 17. Used guitars, he wanted decent ones.
Had you ever met him before?
Yeah. So he wanted these used guitars, very decent quality. He said decent quality, and I said, okay, you know, kind of tall order because most of the guitars we get in are real junk. So I had to go. I told him to take me a little while. I search around on the internet, blah blah blah, and next thing you know, I got all the guitars, And I called him up. He said he didn't need it until like July, I think 21st. So we didn't have a deadline other than that. So as soon as I got my the last guitar, which I tried out, I got plenty of them, and I sent some of them back, but because they weren't good.
Now, you sent other ones back because they weren't good, but
Right.
you kept some. Okay. Did Mr. Spencer tell you what they'd be used for? What kind of condition they'd have to be in?
He said decent, playable.
And to you, what does that mean?
That means decent and playable. It means you plug it in, bing bang boom, it's music comes out.
But one second, did you know what these guitars were going to be used for specifically?
He said that they were going to have some kind of a contest or something, and they were going to be giving the guitars away. Yeah, he said something. Yeah.
Okay.
I know for a fact, Your Honor, that Phil went in there explaining that they were going to be used in an outdoor setting. Therefore, they had to be amplified.
Yeah, he told me that.
Okay, so when a guitar is played, it has to go past volume 5 in order to work. The distortion, Your Honor, was so intense, dogs were coming from 3 counties around with this high frequency noise. I mean, it was incredible.
Can I say something?
Decent shape,
Decent, they were all decent.
they weren't working.
Well, first of all, Phil Spector, or Spencer, whatever his name was, so he tried to act like, come into the place and he plugged them all in and tried them right in my shop. And it's not, I mean, he went wow.
Inside your shop.
Of course. Well, listen, we didn't take it out onto 8th Street. I mean, and he plugged them all in, and each one that he tried worked and was fine, no distortion whatsoever, not in my shop.
Mr. Raven,
Yeah.
let me ask you this. How long have you been in business?
22 years.
And what is your return policy?
My return policy on brand new items is the manufacturer's warranty. On used items, I got a big sign right over my cashier. It says no return policy, no return at all on used merchandise.
You have a sign stating no return on used
Big in
items.
God we trust.
Okay.
Your Honor, if I may say something else, I understand that there's a sign there, but usually when you promise something, that's what you're supposed to get, okay? So if he said it was in decent shape, then they should be functioning. And 9 of those guitars were not functioning. That's more than half.
Now, when you say not functioning, you couldn't use them to give them away?
Well, no, that's the problem. We were at the concert, we had the sound check, and the band started to turn them up past volume 5, and it was like a Nirvana concert. I don't know if you know that hard rock metal band, but it was not plausible to the ears. And my bands that I represent were very upset. They did not get to perform the way they needed to perform.
Okay, ideally, what would you like to, how would you like to resolve this matter?
Well, I would like to be compensated for those 9 guitars, which I think is approximately $437 per guitar. Out of the $7,500, it's about $3,933, roughly. But to be honest with you, the reason I'm here is I would like them to at least get more than that, a slap on the wrist. I mean, this is a shady proprietor and a shady merchant, where who knows where he got these guitars. They could have fallen off of a truck on their way to a repair shop or to a guitar funeral or something, because they were not working, Your Honor. And I've lost a lot more than the financial aspect.
Okay,
Can I say something here?
yes,
or what?
Mr. Raven.
Well, I just want to say that, first of all, I don't know who she has on the bill, but all I know is that a lot of musicians that come into my shop are morons. They don't even know where to plug a guitar in.
These are professional musicians,
Well,
okay?
all right, 2 things. Number 1, I don't know who these people are, whether they plugged it into the wrong hole or not. Number 1, maybe they plugged it into distortion. Number 2, I don't know what kind of amp they
So
were
are you
using.
saying that you think that they possibly could have damaged the guitars after they left your shop?
Without question. Are you kidding me? Listen, this Phil Spectrum guy that was in there
Spencer.
plugged every single guitar in, and every one of them was working, and he wrapped them up and took them with him. I mean, personally, I think that if they weren't working to his satisfaction, he should have said something right then and there before we went through the transaction.
All right, I've heard enough. I will return with my ruling.
Thank you.
Thank you, Your Honor.
Okay. So now I'm going to ask you, okay, so who do you think will win? If you think Lenny's is going to win this, then raise your hand. Okay. Why? Anybody? You think Lenny's is gonna win? Yes.
I think it's pretty persuasive that someone tried their guitars in the store and.
Absolutely.
So,
I agree with you. However, I agree with you, but I'm just going to show you why, it's good to have a contract and what can happen.
In the case of Jeanette Sears versus Lenny Raven, I find that there was no express warranty for the guitars. However, I do find that there was an implied warranty of fitness for a particular purpose. The reason being that Jeanette Sears' company made it very clear to Mr. Raven exactly what the guitars were going to be used for, and they weren't fit for that purpose. So I'm awarding damages for the cost of the guitars themselves. In addition, I find that there are foreseeable damages. He knew that if Jeanette Sears' company tried to use these guitars or tried to give these guitars away, that they would not be acceptable to the public. So I'm going to award damages. Really, this case came down to a question of credibility. I found Jeanette Sears to be very credible on the stand. I don't think that there's any reason why she would have destroyed the guitars after the people in her employ took them from the store. I think that the guitar was not fit for the purpose it was ordered for from the get-go.
Okay, so now, so you can see how, shifty things can get in life, okay? And so the whole idea is that we want to, in some respects, reduce what we call this kind of risk. Okay? There's no contract, And quite frankly, we talked earlier about those representations and warranties and the reasons that you have both of them. A warranty is a very low standard when you go into court. You know, when people in a situation like this, people get ready to sue for breach, they're going to sue for breach of contract, they're going to sue for breach of warranty, they're going to sue for breach of express if it applies, even if it doesn't. And then they will plead what they call alternative pleading, implied warranty for fitness for a particular purpose. And so this is why we have to be able to look at what kind of business problems can come up so that we can write contracts that will try to reduce these kinds of occurrences for the client. That's the whole point of, you know, of this. These are people that are trying to play fast and loose without attorneys. And you can see now the usefulness of having a good attorney. Okay, so now I want to ask you, like, let's say you got this transaction, and that is, I'm giving you my deal memo because I want you to get into the habit of constructing a deal memo. I really want you to do a deal memo for transaction number 2. Okay, and let me tell you why I do that. You see, I like to put all of my information. This whole thing is really like a puzzle. I keep saying that. It's like a puzzle. And once you get all your pieces out, you will find that the problem with this and a regular puzzle is that you get all the pieces and all of them go together. This box is going to have pieces that don't go into the puzzle. You have to figure out which pieces go into the puzzle and which ones are just irrelevant, just folly. Okay? And so I like to get all of my pieces. You get student instructions. You get, you know, another piece of paper that has a whole bunch of information on it. Then you get another piece of paper that has a whole bunch of information. You need to be able to take from all of those pieces. I like to put everything. I like to put my instructions in my deal memo. You'll see I'll have at the bottom, I'll get it all straight, what sections need to go. I go into my student. I put everything. I like to get it all and put it in all the stuff I'm going to need. I like to put it in one place. And that's why I want you to have a deal memo. And I want you, I know some of you probably didn't use that business issues worksheet. I'm hoping that many of you did. But you got to use your business issues worksheet because it clarifies where the problems are. It really just does. Okay, and so once you do that, then you'll have all of it, you'll be able to consolidate all of your information, your issues, everything in one place. Then when the time comes, you can now go into your contract and start to plug in the pieces. That's really what you need to do. And you have to start preparing early to do that, you guys. I mean, really, transaction 2 is going to be due before you know it. I mean, you really, and you don't want to be the week of they're now, you know, having thoughts about a certain issue, like especially something that would go in the preamble. You should already have any issues that deal with that. You don't want to be in like the week of when it's due, you know, being kind of, you're not really sure about some things that will go early on in the agreement. So this is how you can start to develop also the skill of time management, which is critical. Okay, so I want to know then,
In the case,
what is the first thing that you're going to do to prepare to draft this contract? First of all, let me say this. Now, I wanted to ask you this before, but I wanted to wait to see after I got your answer about who's going to win. So which one of these would you want to represent?
Headspin.
Headspin, really? Yes, that's what I expect. Because why? Because she's what? Nicer? Credible?
Yeah.
And so let me just tell you, you're going to get a whole lot of Lennies. And you got to learn to love the Lennies. And that means you got to be ready to represent for Lenny as much as you would for Headspin. Okay. And so now that I'm breaking it to you, we represent Lenny's. What is the first thing that you're going to do to start to prepare that contract, that written contract for Lenny's? Yes. Go ahead.
Lenny.
Okay, that's great. You're going to interview Lenny's, and now Lenny's has given you now some information, and now I have given you some of that information that I have gotten from interviewing Lenny. Now, what are you going to do next? Yes.
Maybe write out the facts and see if I have any questions.
Okay, all right. That thing that I love to do so much. Yes. Yes. I'm going straight to my business issues worksheet. I'm going straight for it. Okay. Now, I want you all to start getting into, I want you to start getting as excited about it as I am. So that's the first thing I have to do. I have to go find my business issues worksheet. Okay. To deter, that's how I'm going to be able to, because I already know, I kind of have a good idea of what Lenny, what his main, deal is. He don't want to be sued. Okay, he does not want to lose money, but I need to be able to dig into all of those issues. And so the way that we do that is we do that with the business issues worksheet. Okay. All right. And so I go in, I've already given you the, my deal memo. Based on my interview now, I have taken advice and I've interviewed the client now, and I have this information. And now I'm finding that Lenny's is just frantic about his profit margin. Okay. Obviously, you would be too if you had this type of business. You got a lot of used junk stuff that you're selling. And so somebody takes that thing, take it home, it don't work or whatever case may be. I mean, good Lord, how you gonna make money in that kind of environment? You got to have a process, people coming in there, they buying, stuff. And so I have to put it on my business issues worksheet. Okay. And so when I look at this, Lenny's is so frantic about his profit margin and losing money that Headspin will sue him over the deal. Okay. So when you see that, I know you all are like, woof, but I need you to get into the habit of being able to put these things down on your business issues worksheet and just say to yourself, okay, what kind of issues do I see? What does anybody see any issues just from that? Yes. Okay, definitely. Tell me what, like when you say risk, risk of what? Yes. Or what was that thing I was just saying earlier? Because he already has the sign up that says he does not take anything back. So he's not gonna take it back. So what she's gonna have to do is sue him. And then it could be, we're gonna talk more about this later on. Somebody did have a question in their online exit ticket about, these are all. When we talk about in-game, we talk about remedies, indemnities, termination. These are like in-game type of things that we're going to deal with a little bit later on as we go along. But it is still something that I can see there in-game remedy. I may need a remedy in there because I'm letting you know that this is the deal. Take it or leave it. No refund. If you sue me, then I need to have some type of remedy. We need to have some type of agreement that there will be no suits. We have our arbitration agreement, but if you then go ahead and do that, then I need to have a remedy in there. And we don't know yet what that might be, but some type of remedy, you know, some monetary damages to come back for you suing, because I'm trying to reduce all of my risk, because all I do is sell junk. Okay. So this is how, this is the purpose of all of this. And now I'm not going to spend too much time on this, but look, I put everything on that chart. Lenny states that the guitars are of decent quality. Okay, are there any issues here that anybody can see? Say that again? Yes. So that's going to be what kind of issue? Say that again? Standards. Okay, and it would be, and you wouldn't, how would you fix that problem then? With what?
Either define it as to what both parties agree.
Okay, and so what did we call that? Remember those concepts?
Yeah, absolutely.
See, you can see these are the kind of questions I'm going to be asking you over and over and over again. You see, it's the same thing, really. And when you get ready to do your transactions, you may get stuck, okay? But it's really all the same thing over and over and over again. And so then I'm trying to give you ways of being able to, you know, get out of the sticky parts, okay? And so once I do this, you see how I have my issues, I have my concepts, I have everything there. So all then I need to do is go back to my thing. I go back and look at my worksheet. Yes, sir. So what did you find out? I'm still waiting. You don't have it? No? So I need you to be able to get those, like, they need to be like.
I have a standards question real quick. If we can't define it, the textbook talks about.
No. There's no such thing as you can't define it.
Well, if you say to the best of the client's knowledge, you can't really define the best of the client's knowledge. You're just saying as far as he knows, there is.
No, it's not going to be as far as he knows, because our job is to fix the problem. So what we say the definition of it is, that's the definition. Decent, playable. Okay.
In this particular case, he can define it, but let's say in terms of a corporate officer knowing whether or not something occurred or not. That's a standards issue. You can't say he doesn't know, because then you're setting yourself up for a very high standard. So you're trying to drop the standard and say, to the best of client's knowledge, he doesn't know. No,
but that's not really would be a situation in a contract, because we have to, this is all about fixing problems. So if he doesn't know, then we don't need to talk about it. It's some, you know, this is something different, I think, that you're visualizing, but.
Well, it's under the standards section in the book. It talks about how you word things to reduce your client's risk.
Right. But when we're talking about standards, you know, defining things, then I understand what you're saying. They're talking about a varying, you know, if it's if there are 100 miles on it, you don't know, you know, you may not know to the best of what, but, and so, you know, in order of reducing the risk in that situation regarding representations and warranties or something like that, that's different. That's really more of a, go ahead.
I was going to say, let's use the stove case with the 180,000 hours, and I put approximately. I wanted to kind of lower the standard.
Okay.
I didn't want to say there was exactly 1,800.
Okay.
How do you define approximately?
Yeah, approximately.
Do you need to define approximately means?
No.
Oh, okay. All right. That's.
Yeah, because you're already saying that, you know, we're not saying, you know, it's exactly 1,800. You're saying approximately, and that's fine. Yes, sir. Yes. Declaration. And so you're going to have a declaration, and that is going to be to define the meaning of decent. Okay. So I have my concept there. And in my mind, for right now, I know that that's probably going to go where? In what section of the contract? I don't mean.
I would say define. I mean, obviously.
Okay, yeah. And what see how I'm trying to get you to start thinking? Okay, so I'm just looking for that one word. What section?
Definitions.
Yes. I'm not trying to trick you. Yes. So now you have your concept, and you have your section, and you have your issue. Okay? All right. All right. So now we have that. What else can anybody see? Yes.
I just have a question. Let's say for decent, we take a dictionary definition. Do we need to, like when we turn into transactions, how you wanted us to cite to the precedents we use, do we need to cite to a dictionary that we use?
No. But I wouldn't use a dictionary definition. Okay? Because we have client goals. Okay? All right. And so we have to follow the facts. Okay, and so if you use a definition from a dictionary, that may be outside of what our client needs it to say. We just need decent, playable, bing, bang, boom. That's what we need. If you make it real decent, like from the dictionary decent, that's gonna meet the judge's standard. When I need the judge to realize we agreed it means this lesser thing, just decent. Now, if you are the attorney for Headspin, when I send you this draft and I say, oh, decent, playable, bing, bang, boom, what are you going to say? See, because this is how attorneys do. I send you the draft. I'm like, here you go. And you're going to say,
Than 5, playable up to 9.
thank you. If you need it to go up to 5, 4, 3, 2, or whatever, you better put it on there. Then you bring it back to me, and I'm like, oh, okay. You see what I'm saying? Then everybody's clear on what. But how is he supposed to know? The person comes in, they accept the product as it's decent. How's he supposed to know it needs to go up to 5? So see, we're all, on the same sheet of paper. Okay. And so I put it all down on my worksheet so that when the time comes, then I can fix this problem in the contract. Okay. And so I may need to have, because this is going to be a risk issue if we don't solidify what that means. You're telling me now it needs to go up to 5. Okay, great. But if we don't solidify that, then that's going to be risk. So I need to control that now with a promise from the Headspin saying, okay, now, all right, great. We've defined it well, but once you come in and you accept this, that's it. I'm done. So that's how we go about doing that. And so that's why I like to put all of my information, from the beginning on my, in my deal memo. All right. And then I am going to, have my worksheet. And then that way, once I have all of these things together, then I can start to look at working on drafting that contract. And so now that I can see, I have all of I know that I have my sections down here that I'm going to be working with. This is the framework that I have been given. I've been given my format. I have it all here, put it all in one place so that when the time comes, I make sure that I am working within the confines of all of the instructions that I've been given and that I can make sure that I do the best job for the client. Now that we've determined what those business issues or goals should be, then what do we need to think about next? And that is going to be our contract sections. So these are all the things that we think about when we are thinking about writing that contract, the contract concepts, our 5 issues of concern, and then globally our 10 contract sections. Right now, we're still working with our 7 right now. But you want to be mindful of the sections that you're going to be working with. And again, so what I say is I like to go in then and just start to set it up. It's like a puzzle for me. So I set it up so that I can know that because see, once I realize what all the sections are that I need to have in there, then I can make sure that I'm checking off my list. I have everything that, and so, because there will be some people that'll turn it in, they will miss the exhibits. I am grading each section now. If you miss the exhibits altogether, then I won't be able to put points in there for the exhibits. So to reduce that problem from happening, I like to go in and start off in the very beginning and put all of my sections down that I need. Yes, sir.
Do we have exhibits for our show transaction?
Did you?
Oh, okay, sure.
No, I'm asking, did you? Why are you asking me that?
I don't know what exhibits were.
Well, I'm just saying, we're not asking you to go out and actually put exhibits, but I mean, you need an exhibit section.
Oh, okay.
Yeah, I don't mean you're going, because the instructions specifically said that.
I don't think things, I'm sorry.
Okay. I know, but what I'm saying is that you would just put like a heading to say this is what the exhibit A would be. So we're clear. We're not manufacturing exhibits, but you still have to be mindful of what exhibits you would need. Okay. I'm sorry, I didn't mean it. Okay. So now that I got this all set up then, so what am I going to be working on first? Anybody? Yes, ma'am. The introduction. So I'm going straight for my introduction. Okay. All right. So if I'm going to be going into that introduction, what do I need for the introduction?
Find the contract, find the parties, and
3 things. It's always going to be the same.
preamble.
Yes.
So,
Okay. 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 So now, right now, I'm talking about the introduction globally. For the introduction section.
Oh, preamble is
Yes.
the word agreement?
The words of agreement. Yes. Okay. Very good. I'm just trying to get you to see it this way because, when you get ready to do it, so you don't get stuck, you always know, boom, boom, boom. This is what I need for my introductory section or my introductory provisions. My preamble, my recitals, and I need words of agreement. Okay? Now, let me go back to this. Some people get kind of confused about it because, and I don't care how you do it. I like to put my title, and then I'll come down and put my preamble, and then down below that where it says Article 1, I'll start with my recitals. But if that's confusing to you, that's all the introduction, okay? If that's confusing to you, after your title, you can leave Article 1, Introduction, there, and you can put your preamble and your recitals right underneath there. But that's all in this one section. That is what this section is comprised of. Okay. And so now if I am going to be working on those, on the introductory provisions, and I know that the first thing that I need to do is to start with the preamble. Okay. And then, so then I need to ask myself, okay, what do I need for the preamble? Okay. So now, what do I need for my preamble? Yes, that's right. Okay. See, we covered this in the last class. Okay. Okay. So now it's like riding a bike. Okay. So now all I'm doing is I have my section set up. Now I'm just going to start plugging in the things that I need. Okay. So you can go to your deal memo. That's what I would do. I go to my deal memo and I start asking myself, okay, what is it from this that I need? I start to highlight and try to isolate information from this to be able to start to plug in my pieces when the time comes for me to start to write that agreement. Okay, so you'll get this information in your deal memo, you'll get it in the client, it might be a client memo, it might be a term sheet. You know, these are kind of the places where you will find this information. I like to put it all in one place. Some people like to deal with it in scattered format. You know, they'll try to highlight it here and highlight it there. I like to put it all in one place. And so it does require an immense amount of reading, and rereading. And so it is also the development of that particular skill as well, the critical reading, which is what you need to be able to do this thing we call analysis. Okay, and so with that being said, the first thing that I'm going to do is to name the agreement, something like, you know, bulk use guitar agreement, you know, sale agreement, something like that. And then I'm going to, you know, think about the date. And obviously the information that you're going to be given in your deal transaction information, you have to follow that information. So you have to use whatever date you're given there. And sometimes you may have transactions that may be, you know, for, you know, maybe 2018. You have to put yourself back in that time and work the problem out based on the facts of the information that you've been given. And so all of these things would need to go on your worksheet, your date, you know, any of these things that might create some type of an issue. And then here, your deal memo or your term sheet or whatever information you have is going to give you information about your parties. And again, we have stated that the thing that we need to do when we talk about the parties is we need to identify and define. Identify and define. And so we have to identify who the party is by their name, their legal name, because we need to be able to bind that party in the end. If something happens, if there's some type of breach, you can't go sue John down the street. You have to be able to sue the entity that the agreement is made on behalf of. And then at some point, we want to define the party, so we'll have a quick way of being able to talk about that person in the recitals. Okay? Okay, so now we have our deal memo. All right, and so the first thing we want to do is we want to name the agreement. Okay, so what name could we give to this agreement? Yes, something like that, okay? So, when you all, when you give your name to your agreement, it is what it is, You say sell, I may say purchase, whatever. But once you name it, that's the name of the agreement throughout until we get down to the definitions, okay? And so then I start my preamble, this bulk used guitar purchase agreement. And then now, what is going to be the date? Because we're using our deal memo. Yes, ma'am. Yeah, we would do February 4th because we've been given a closing date now. We're given a hard closing date here. And so that's going to be the date of the agreement, most probably. All right. Now we need to, so first thing that we're going to do is to identify. So what will be the identification of these parties? I like to start off with the seller, so let's say is between who? Yes, ma'am.
Lenny's Music in California.
Yes. Lenny's Music, Inc., a California corporation. How would you define that then? Seller. Okay, that's great. Okay. And who else?
Has been Records, LLC, California Limited Liability Company.
And how would you define that?
Buyer.
Okay. Great. Okay. I like to use the names. Seller and buyer, but everybody has their own thing. Okay. But once you define that as such, in the recitals, that is the name you would use. Okay. So these are our 3 elements now that we need for that preamble. Okay, so now, now what do we need? We have our preamble. Now we're going to work on what? Recitals. I like to do recitals and words of agreement together. So we're going to do our recitals and the words of agreement, because the words of agreement is just the end of the recitals. Okay. And so now this is where we now need to, pick out, some information that is going to reflect the background, paying close attention to understanding the client's goals, the goal of the client in this agreement. Now, I mean, we don't need to put all of, his business out there. We know he doesn't want to get sued. Okay, but we want to find a tasteful way to make it clear why we're entering into this agreement. And so now, how are we going to start off with that? I like to start off with just giving just a little basic background. Okay, so what would be a good way to start off our recitals in this particular case? Anybody? Yes, ma'am.
You could say what money sells.
Yes, yes. Just a little brief introduction, and then just that's all we need, you know. And then what would you say next? Now we know who Lenny's is, and so what will we say next about him? Or what would you just say next? It doesn't, because this is not, you know, it's not so rigid, you know. It doesn't have to, yours may not be mine. The next thing you say, what would you say?
Would you want to address his tight profit margin?
Yes. Yes. He's frantic about it, you know. I don't know if I would, you know, but we definitely want to just say that he doesn't want to incur loss from the sale of the used items in the store. And so you want to give the background. You want to make it clear when you go to the judge, and so she won't be, you know, loosey-goosey. Look, this is why I'm doing this, judge. So don't come in here with your whatever you're talking about. Nobody knew what this was as is. Okay, it's a pawn shop. It's like a swap meet. I mean, I'm from the South. It's a swap meet. So what? I mean, really? What? Okay. So, all right, we got that now. So then now, what would we want to introduce a little bit about now? What would we want to say a little bit about now? Yes. 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 So you just kind of lay the foundation for yourself so that you can understand what's going on, you know, in the transaction. It's even just for yourself. Okay. So headspin, you want to talk about headspin, just a little bit about headspin, what they do, and that they want to buy these 17 decent quality, you know, guitars. Just give a little background. Okay. What are we going to say next? We talked about what headspin wants to do. Then, so now, I mean, what they're, you know, what they're looking to do. Then, so now what are we going to say? Just something just to tie this all up here. Yes.
Would you then want to move into the risk agreement and say therefore Heston is buying? Or
I might. But let me just tell you, I'm just a legal person. I like to box people in all the time. So I just want to say one more little thing there. I want to make it clear that there was an inspection, judge. I'm always setting myself up to go in front of the judge to explain my case if the time comes. These recitals do not bind the agreement, but it's going to give the judge an idea of why we entered into this agreement. After inspection, I just slip that in there. You know, I just say, by the way, after inspection, they want to purchase these extremely decent guitars from Lenny's. I just want to put that in there, just sneak that in there. Now, see what I do? All of these things are up for negotiation with opposing counsel. I just slip that in there. I'll send that over, and then she might say, "Oh, no, thank you," you know. But that's not for me. That's non-negotiable, because that's, you know, my goal is to make it clear. The client goal is to make it clear that you want to lay the foundation for why there will be no return, no refund, as is, no warranty. This is it. Okay. Then I'm going to take your advice and go into my words of agreement, which I have said to you, it just can't be. I like to lay the foundation here for that thing that we're going to talk about this evening, which is the action section, a very, very critical part of the agreement. I like to see you put here some splattering of what you would have in your action section, your subject matter performance provision, which is definitely binding. Okay, so I like to see students set it up here. Once you set it up here, then you can go straight into that. If you pick this up next week and start working on your action section, you can go straight from here and start working on your action section. Because this, to me, is now going to be a statement of the consideration from both sides. As such, this bulk use purchase guitar purchase agreement provides for the sale by Lenny. That's what he's doing. That's his performance. He's going to sell, and the purchase by Headspin, by her performance, is payment of the purchase price. I like to put that in there, right there. That's the first part of my words of agreement. Then what do I have to say next?
Accordingly, the parties agree.
Yes, the magic words. So sometimes I see students, they just have accordingly the parties agree. That's not, you don't have two parts. All you have is your one part. You have your magic words part of the words of agreement. But you need your consideration part and then your magic words part. It's a two-step process for the words of agreement. Okay, so now I'm done with the recitals here, okay? That's what it looks like. Now, I'm going to stop here to say that I found that there was like some numbering. You need to number your recitals. When you start to shuffle this back and forth from opposing counsel to yourself, like you might even be on the phone and be like, oh, I'm just aghast. And then you'll be like, well, what's wrong? You need to be able to say, well, Article 1.1. Okay, and so some people didn't know, and I know the samples don't have that, and this is what I'm saying to you is in the practice of law. I've been doing this for many years. Somebody call me up on the phone, that's what they like to do. They'll send you an email. They'll be like, oh, this section 2.2, my client is not gonna go for that. You have to be able. You can't just say. You have to be able to point to what the problem is. And so the way of being able to do that is to number and to have everything to number uniformly throughout the agreement. Some people may say 1.0 and then they may have something under this that relates to that. They may say 1.0A. I like to use numbers all throughout. So I would say 1.01, me personally. I just like to keep numbers. But there needs to be some type of identification of each one of these provisions so that we can say what you're talking about. I'm talking about 1.0A, 1.0A sub B, whatever it is, you need to be able to identify what we're talking about. Okay? All right. Are there any questions about that? All right. So, how am I doing on time? Okay, got a little bit more time. Okay, so now after the introductory provisions, then I do want to start to work on the definitions. Okay, now last week we talked about definitions. Okay, so for our definitions, you want to review your deal memo. Hopefully you have done your worksheet. But just before we even get to any of that, last week I talked to you about definitions. I told you the first thing I do 4 definitions right out the chute. And so the first one of those is what? Yes. We name the agreement. So now once I do that, I say name. We define the agreement. Okay. So once I do that now, once I define this agreement now, I don't have to say this bulk use guitar purchase agreement all throughout the agreement. Now now that I have defined it now as agreement, from that point on, I can refer to it as the agreement. Okay. So that's the first thing I'm going to do, is name the agreement. Then what do I name? Or what do I define? Then I define the parties. So boom, boom, boom. I'm just showing you how you can't get, on these pieces, you can't get stuck because you know what you're going to do next. I'm going to name the agreement. I'm going to define the parties. I should say define. So then Lenny's. So now I know for a fact who Lenny is. He is the seller of the bulk set of guitars. Lenny's shall mean Lenny's Music Inc., a California. Now I can definitely throughout, or if you're going to define it as seller, that's fine. So definitely now throughout this agreement, when we say seller, we know who we're talking about. And then head spin. Then what do I define? Yes, ma'am. The thing that the agreement is about. The 4 things. I define the agreement, the parties, and then I want to define that thing that the agreement is about. Here is the guitars. Now, I have, I put this on my chart, so now I can see all the risk and all that. So that is why I know now I want this to be delineated as a bulk purchase so that a person cannot think that, if any one of them is broken, that they can come back and get their money back on. No, it's a all or nothing. $7,000. Don't piecing off a piece here and try to come back and get money. No, it's like one thing. It's one unit. I am reducing risk for my client in that way. So I want to make it clear. It is bulk. It is a bulk set. So then for that purpose, then I need to define bulk set. So that it will be clear. It is a collective. It is like one thing. All right. Now at that point, I'm like, okay, so what am I going to do next? So then what do I do? When I need to look for other definitions, what should I do? I'm going straight for my chart. Because now I'm stuck. I'm like, oh, what do I do now? Let me pull out my chart. So then I go and I pull out my chart. And then so I might find a few definitions on my chart because that's where my issues are. That's where my problems are. Okay. So I'm going to go, and my friend has told me, you need to define decent. You need to define what decent means. Okay, so I know that I need a definition for decent then. Okay, you see? You see how easy this is now? Yeah. Okay, so this is what I do then. And so I say decent, Madam Judge, shall mean fit, suitable, all the words you want to use when you try to come at me and tell me this is implied, this is a breach of implied warranty. I'm going to refute that, Judge. No, so that decent, this is what decent means. So I'm not going to necessarily go to a dictionary, but I want to get my client out of this issue. You see what I'm saying? And so I may go to the law to do that. Find some little buzzwords, put in there. It's going to be fit for whatever it is she want to do. It's going to be mercantile, playable. I would not put bing, bang, boom in here, but in my mind, that's what I'm thinking. Then 2.6, I'm going to define inspection. Inspection shall mean the inspection at closing of each of the guitars conducted by head spins manager officer with authority to sign this agreement to determine if the guitars are of decent quality. I am fixing business issues. And so eventually, at some point, I am going to have some type of a covenant that may kick this definition into action, because it by itself may not be binding, but I need to define later on when I say the head spin promises to that they shall conduct an inspection. Then I will know what I mean later on by inspection, because I will have defined it. Okay. And then, I always define cash, money, whatever it is, so that everybody will know what I mean when I say cash or whatever form of payment is going to be. But for me, it always needs to be certified funds. No, I don't take personal checks. I don't take law firm checks. I don't take checks of any kind. It needs to be like Bank of America, Wells Fargo, cashier's check, electronic transfer. If you want to bring a boatload of cash into my office, by all means, do what you need to do. But it needs to be something that I can liquidate. I don't do checks of any kind. I don't ask anybody if I take a check. I don't take checks. So I need to let everybody know what cash, because later on I'm gonna say cash, but I don't mean cash like cash. I mean it needs to be certified funds. Okay. Because we don't walk around with $29,000, in our pocket. So now we're going to talk about that thing that we all gathered here to talk about today. See, now we have the things that we've already talked about. We talked about our introductory provisions, our definitions. I'm going to come in later, talk about signatures a little bit. But then now we are ready to talk about the business/action section. Okay, and in that context, we always want to put the actions first. Okay, I'm gonna go for another 2 or 3 minutes. Put our actions first. Let me just talk a little bit about actions. Okay, now they refer to the main subject matter of the agreement. Okay, the promises that the parties expect to exchange between each other, rights and obligations, the money or what other value is going to be exchanged, the payment provisions. Then it was going to talk about the term or the length of the agreement, if that applies, any closing obligations or closing documents. These are the things that will be included in your action section. Okay, so now we are dealing with our action section. We're in our business action section, just section 3 of the agreement. And again, we want to start with the action section first. And so if there's anybody who can tell me those first 2 provisions of the action section, what are they based on your reading? And this is like reading from this past week. So business, yes.
The purchase agreement.
So this is the action section. The first 2 provisions, your first one is going to be what?
The subject matter performance provision.
The subject matter performance provision. And then the next grouping or the next one is going to be what? Payment. So boom. I know that, first of all, I know, now what I need for my introduction, I need, these 3 things. And then from those 3 things, and I need these 3 things. And then I know for my definitions, the first thing I'm going to do is my first 4 definitions. Boom, boom, boom. And I'm going to go to my chart. Then when I get to my business transaction section, I know the first thing I need to do is my actions. And I know that my first two provisions are going to be my subject matter performance provision and my payment provisions. So then I'm going to start right there. Okay. All right. And so when you get ready to start to draft those, though, you want to keep in mind that, remember, I told you in that first week of class that you have those two types of promises, because we know that that subject matter performance provision is made up of what? What concept? Covenants. Yes. A promise to perform. Now, when I talked to you in the first week, I told you that there could be two types, though. What are those two types? Yes, sir.
Executory and self-executing.
Yes, yes. Remember, we talked about the Ralph's deal, that Ralph's particular promise is what type in that particular aspect of, based on what you just told us.
Self-executing.
Is a self-executing. It's the signing of the agreement would be that type of a promise. Now, what I want you to know is that for your subject matter performance provision, I'm going to ask you, what is the least amount of promises you're going to have in that subject matter performance provision? 2. Okay. You need at least one. You need one of these types for each one. I see sometimes in the subject matter performance provision, there's just one person's promise. Ralph's promises to do whatever, and then that's it. Doesn't say anything about merchandisers. Okay, so in your subject matter performance provision, you need to have you need to have the reciprocal promises for each party. What one is going to give, what the other is going to give. Again, when I say to you, you should not get stuck, because the first thing you do when you go here is you can go back to your words of agreement. And it should have a representation of what was there. You need to at least start off in your subject matter performance provision by setting out that type of information. Remember, when we went to our Ralph's deal, I showed you on the chart, Ralph LP, because again, they laid it all out for you real nice, with the client issues or the client goals. Okay. And then we just put it on our chart. And then, so Ralph LP will grant merchandisers a license for caps and t-shirts. Okay. So I know I'm going to go over there and say, okay, well, I know that I'm going to need a self-executing covenant. Merchandisers then will have a right, but I put it over here because at some point I am knowing that I want to deal with this issue of Ralph likeness. And so I know I'm going to have a standards issue there, but for the covenant itself, I know that's going to go in the action section. I go ahead and I label it. So when I get ready to do my agreement, I'm going to pull out my chart. I'm going to go into my section 3. I know that I need to have these two promises. I'm going to go straight to my chart and just make sure that I have what each person needs to be promising. And then I see over here that merchandise is going to need an executory type of a promise to market and merchandise the caps and t-shirts and to pay the royalty payment. I just want to slip that into the subject matter performance provision, because when you put things in the subject matter performance provision, it gives certain rights, walk away rights to the other party. And so there's some things I always like to put the money, I just like to just say and make a brief statement that somebody has an obligation to pay in my subject matter performance provision. Then what am I going to do next? I'm going to, after I get my subject matter performance provision, then I'm going to solidify that in my payment provision.
Do you want us, when we're writing the covenant, do you want us to also immediately after that, I remember you said something about this a couple weeks ago, write, it also gives the other party the right. You want us to have both of those words?
No.
Okay.
No. I'm just saying to myself, I know that a covenant gives certain kinds of rights. So that's why I want to have this particular part in my subject matter performance provision, because the subject matter performance provision, if somebody does not do something that's in the obligation in a subject matter performance, that gives certain walk-away rights. We'll talk later on about, our conditions and all these kinds of things. But that flows from the subject matter performance provision. Somebody, will ask, well, is this with this particular condition, if this person does not meet this particular obligation, does it create a walkaway right? Or, so it flows from the subject matter performance provision. And so that's why sometimes I like to put a little bit of oomph on that payment, just to sneak that into that subject matter performance provision. All right. And then here, Headspin is interested in purchasing 17 used guitars from Lenny's. And so we have our risk, the risk of the warranty. And so we said that, I said that the sale of the bulk used 17 guitars in that particular covenant, and Headspin's obligation to purchase that bulk set of 17 guitars from Lenny's. And so whenever I have now defined that bulk set, then that creates that obligation for that person to buy or to purchase those 17 and to pay the purchase price based on the 17, the bulk set of the 17 guitars. Okay, so the next thing that we want to then do is to deal with the payment provision. And so this is just now, it creates another obligation. And again, I have stated to you that I like to do it, me personally, I like to do it as a declaration covenant combo. I like to have a declaration. And so as we've stated, all of these different concepts can be in any different places, any of the different sections of the agreement. You don't necessarily have declarations just in the definition section. But here, if I want to define that amount, the only place that I can do this definition is in the action section. And so I define the amount, and then I have an obligation then in the form of a covenant to then pay that amount. But then you need to be clear and ask yourself before you move on from your payment provision that you are answering pay what, to whom, when, and how. So there is no equivocation on anybody's part on what is to be paid, how it is to be paid, when it is to be paid, and to who it is to be paid. It creates a right in Lenny to receive that payment from Headspin. If something happens down the road, that is a right that is now a legal right that is created in Lenny to receive that payment. And so we talked about that earlier how you can do, just a covenant with all of that information in it. I like to do the declaration and the covenant. And then you will also be able to, if it's a more complex deal, like a ski lift, it could require you to, delineate, other sections, because maybe all of the payment is not coming from one particular place. But it needs to be clear in each section what is coming from where, who is going to, how it is to be done, cash, electronic, whatever the case may be. You need to be able to be clear that you are answering all of those questions in your payment provision. And so obviously you're going to, get information from your deal memo, from your chart as well, to be able to complete that. And so I have here my purchase price. I have, what, if any, types of issues could result from that. I have the sections. I have my declaration. I know is going to be in my definition section, where I have defined the meaning of cash. And then that declaration in the actual payment provision that is going to define purchase price, which would be $7,500. And so I have all of my information on here, because, this could be a money issue, loss of money if not in the form of certified funds. It is a risk if Headspin leaves a store with the guitars and the payment is returned for insufficient funds. So how am I going to control that? I'm going to control that with the standards. That creates a standards issue, so I'm going to control that with a definition in the declarations, defining exactly what kind of payments will be accepted. I'm going to control it with a covenant in the action section, pay what to who, how, when. I may control it in the representations, where it will be stated that Headspin represents that it has the financial strength to pay and guarantee that payment. If something happens later on, then, then you may control with the declaration defining the meaning. So I have all of my issues here, so that when the time comes, I can just plug them in wherever they may go. Okay. And so here I have my subject matter performance provision. Lenny shall sell the bulk set of guitars to Headspin, and Headspin shall buy the bulk set by doing what? The performance, paying the purchase price. What is the purchase price? The purchase price is $7,500. I have that defined here. The purchase price for the bulk set of guitars is $7,500 payment. Headspin shall pay what? Shall pay who? Lenny's. The purchase price. We know how much that is, $7,500 in cash. When? At closing. Cash has been defined. Certified funds in the form of cash or cashier's check in this particular instance. So I have pay what to who, how, when. It doesn't need to go in that particular order, however your sentence needs to flow, but I'm going to be looking for all 5 of those answers to that question that has been answered in that provision, which for me, it has 2 parts in this particular instance. All right, so those are some parts of our action section. Okay, these are all of the things that will go into your action section. So you have your subject matter performance provision, you have your payment provisions. Then, if applicable, you're going to have your term. Okay, do we have a term in Lenny's deal? Great. Why? Why not?
It's a one-off.
It's a one-off deal. Very good. Very good. Not every deal is going to have a term. Ralph's deal, it had a term of years. But when you go, you have some deals that are just like, if I go buy your car, that's a one-off deal. We're done at that moment. There's no term. So then you're not going to have a term. Okay. What about closing date? We have a closing date in this particular deal. So then I'm going to go and I'm going to have a section about my closing date. And then I'm going to have my closing deliveries. Okay. Now, listen, not every deal is going to have a closing. Okay. Will Ralph's deal have a closing? Your closing deliveries, now that's going to be like your, it is the consideration. Like, let's say once I sell the guitars, then the person needs to have, ownership, some type of ownership document now, a bill of sale, some type of receipt, a certificate of payment for the payment. So these are like closing deliveries. Okay. And so here I talk about the closing. The closing shall take place at Lenny's Los Angeles store on February 14, 2019. I talk about what's going to happen there. At which time Lenny's will deliver to Headspin the bulk set of guitars and a payment receipt. And Headspin will deliver to Lenny's the purchase price payable in cash. We talk about our closing deliveries. Okay. And then now your next section is then going to be, I shouldn't say your next section, but your next provisions in this section are going to be your business, what we call the business section part of this agreement. Your action / business, your business / action section. Your actions go first. And then your business sections, they can be any of these that are discussed in your book, which makes it confusing. But what you have to do is it depends on your instructions. So for us, these are the sections that we have. And so what I am going to say to you is that once you go through your sections, let's just say we have all 10, okay? I don't want this just to be just for now. I want it to, go throughout the semester. Anything, all of your provisions that are in our contract sections 3 through 10 are business provisions. And so what I'm going to say to you is any business provision that is not properly placed in sections 4 through 10 should go in section 3. In the business, because all of those, your covenants and your rights and your conditions and all of these different types of concepts are really business provisions. Some of them are going to be in your representation and warranty section, some of your closing, condition to closing sections, signatures, in your remedies and indemnities, your termination sections. If they don't go in those sections, then this is a provision that you need to put in the business part of your business / action section. You put your actions first. We already know what they are. Then after that, then you would put in your business. It may be for me, in this particular case, if I want to talk about some arbitration, I might put it in that business. I might drop it right down in there. So, here I talked on my chart about maybe we can control this risk regarding the decent quality with some type of a promise from Headspin that after they have accepted the guitar, see, I'm going to put that in my business section of the agreement. Now I'm finished with my actions. Next, I may come in with a provision about that. So now let me just say this then. So, I like to make it simple on myself. I have all of my sections already set out that I have started off with. I have my introduction. If for whoever it makes you feel better, you took your Article 1 introduction and you want to put it up at the beginning so that you can have all your, so that, you know, it's less confusing. I'm fine with that. Okay. As long as we have all the sections we're supposed to have. So you put you have your introduction, you have your definitions. This is exactly how I do it. I don't get myself confused in trying to call it anything other than, you know, like some people, they like to, you know, covenants and right. They're all covenants. So I don't want to call it covenants. I don't want to call it purchase and sale. I'm going to call it subject matter performance or subject matter performance provision. I'm going to just call it that. That's what you should call it. Because we are learning so that you can stay in track with everything where it needs to go. And then next, I'm going to go down with my payment provisions. I know I like to do 2. Some may want to just do 1. If you're just going to do 1, then you don't see, I need 3.11 for my declaration and 3.12 for my covenant. If you're just going to do 1, then it's just going to be all in 1, 3.1. I like to do 2. Then I put everything in there. I'm going down my list. I got my payment provision. I don't have a term. I got my closing. I got my closing deliveries. Then next, I know, boom, now business. Once I'm finished with all of that, once I go over to my chart, I have everything I need, then I'm going to move into my representations and my warranties. Okay? Are there any questions about that? Somebody asked, I'm having difficulty distinguishing between the conditions of closing and just closing. So now we can see that closing is in our subject matter, is our action section. Condition to closing is somewhere all by itself. We'll talk about next week or in weeks to come. But our closing is going to give details about a closing if there is a closing. But that's going to be based on your facts that you're going to be given in your transaction materials. And then once you are giving that information in your transaction materials, you need to set it out and make it an obligation on everybody to be present. Even though that is the time when the agreement will be signed. All right, then I want to talk a little bit about your signatures. Okay, we talked last week about our signature blocks. And remember that they need to match the parties' names as they are reflected in the preamble. Remember? And so now that date is from last semester, but we know that we would have our February, whatever, 2019. And the names in the preamble, remember, those has to match the top of the block of that signature block. So Lenny's Music Inc., a California corporation, it needs to be stated at the top of that signature block. Headspin Records LLC, a California limited liability company, that needs to be set forth at the top of the signature block. You're going to have the date that that agreement is signed. And I wanted to talk a little bit about date. I saw that there was some that wanted to use the as of, and I just got away from, because it has a connotation when you say as of. And so, and it's kind of confusing. It's kind of linked to an effective date, representation and warranty type of date, a date that may be before the actual signing of the agreement. And so I just got away from, let's just stick with dated, and let's not try to use an as of date in our preamble. And then let those dates match. It'll just be the date that the agreement was signed.